All rise. Court of Appeals Division 1 is now in session.
Thanks. You may be seated. So we are here on our case number 1CACV170107, Adair versus Bajwa et al. Counsel, as you know, each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself. The clock on the podium will reflect the total amount of time you have remaining, including what you have decided to reserve. We record these proceedings, so we'd be grateful to you both if you would, when you approach the podium, give us your name and the name of your client. We've read the briefs and looked at the motion papers below and the record below. We've also discussed the case in our conference. So with that, you may proceed.
Bernald Porter, appearing for the plaintiff in this case, Your Honor. I don't have much to add to what I've submitted in my briefs with the court. The critical issue, I think, is the lack of service of process upon the defendant. And according to the affidavits of my process server that are filed in this case, he did not accept service until March of 2016, even though the case was filed in October of 2015. And he didn't file an answer until June 1st of 2016. So when we had the oral argument before Judge Talamonte in the Superior Court in Mesa, just a few months had expired since the time of service. I had also asked for an extension of time to provide the affidavit and Rule 26.1 disclosure statement that was required. But when the argument was held, I again asked Judge Talamonte for an extension of time, which he denied to even consider.
When did you ask? When was the first time you asked for an extension?
Because of my health situation, yes.
But when did you ask for the extension? Is there a date on that?
Or was that something you did at argument? At the hearing?
In September of 2016, I filed a request for extension of time in response to defendant Bajwa's motion to dismiss.
So that was after September 12th then? After the, okay.
Yes, it was. And that was because of my health situation. When I went up to Utah to visit my 5 children that lived in that area of Provo, I have a son that's a doctor in Provo. I have 2 sons that are in contracting there, and 2 other family members that were living there at that time. And the mother of my children was deceased, and so I was wanting to spend Thanksgiving with my children. So I went to Utah, and while there, suffered a major heart attack and was hospitalized and operated on by Dr. Acey.
This was in November 2015?
I'm sorry?
This was in November 2015?
Yes, November of 2015.
Okay. Prior to that, so that you had filed the complaint prior to that, and you indicated that the acceptance of service was not effective until in the spring of 2016, but I understand that counsel for Dr. Bajwa had indicated that she would accept service on his behalf as of the end of October of 2015. So can you help us out with what happened there? Why didn't you take her up on that? Why didn't you provide an acceptance of service?
I don't recall why she did not provide an acceptance of service prior to the time that
Well,
that
I think this
actually
is
occurred.
why didn't you effectuate service based on counsel's representation that she would be willing to accept it?
I don't recall those circumstances, Your Honor, but
Okay.
unfortunately, I've been dealing with some health issues in my declining years in the practice. I've been practicing for 57 years now, so those events caused or contributed to the problems I was having in communicating with my client, who was a firefighter that spent most of his time fighting fires in Northern California. And when I needed to contact him, he was not available. I could not reach him. I could not contact him because he was on the fire line in Northern California. And that went on for several months that he was there fighting fire in Northern California. And I simply could not reach him. Tried to reach him through his wife, and she couldn't reach him either. So those efforts were futile. So in any event, I had asked Judge Talamanti for an extension of time to complete service and complete the 26.1 that needed to be filed, and to submit the proper affidavit. And let me just explain what I went through to secure the letter from Dr. Paul Marishin. He is a dentist by profession, and he's a specialist in implants and extractions and tooth replacement. So when I contacted the general dentist that I knew and had association with, Dr. Dana and Dr. David Thomas and Dr. John Hatch, all general dentists, and when I asked them the question, what's the standard of care in the community under these circumstances, they scratched their head, and all three of them said, well, it depends on what the dentist feels he can do in extracting the tooth and how long it's going to take, et cetera, et cetera. But all agreed that I should ask someone who deals with those situations in their practice, and was referred to Dr. Marishin. And Dr. Marishin, even though he's a specialist, he's not a general dentist, but he knows what the standard of care is for general dentists, because he was a general dentist during his practice and for some years after his specialization. But the standard is the same. When the dentist determines that it's going to take an unreasonable length of time to extract the tooth, he should stop whatever he's doing and refer the matter immediately to an oral surgeon. And that's the standard of care under those circumstances. So I felt that I was dealing with someone who knew the standard, who dealt with extractions and tooth replacement and those kind of circumstances in his practice, and could opine concerning the standard of care. The other gentleman that I spoke with, Dr. Hatch, Dr. Thomas, also a Dr. Curtis, they would all give affidavits to the effect that, yeah, that's what you do. You determine what length of time it's going to take, and then you determine whether you should, and if you should, refer the patient to an oral surgeon. That's what you should do. I didn't secure an affidavit from them because everyone agreed that an expert such as Dr. Marishin knew the standard of care and knew what would be required under those circumstances. I can get an affidavit, and I'd be happy to do that, and I ask Judge Talamonte for additional time to secure a proper affidavit if one was required from a general practitioner. But ordinarily, when you have dental malpractice cases, and I've handled many, you deal with dentists that know what the standard of care is, but they all, to a man, refer or defer to a specialist when asking and answering that question. What is the standard of care? So if you go to the website for dentists in Arizona, they're all listed under dentists. No specialties are listed. So you have to know what the doctor's specialty is before you start your search, because there's nothing in the dental website that gives you that information. And Dr. Marishan is listed as a dentist in those circumstances, but he's not listed as a doctor who specializes in implants and extractions and that kind of procedure.
And I'm not sure his affidavit,
I'm sorry?
I'm not sure that his affidavit identified himself as an expert. I thought that was an interesting point. But let me ask you about something else. It appears from our record that by the time of argument on the motion to dismiss, although you had served the affidavit very shortly before the argument, you had not responded to the interrogatories or the requests for production or the request to provide medical releases, and had not served a 26.1 or 2 disclosure statement. Is that all accurate?
It's accurate to the extent that requests were made by one of the defendants in the case. Dr. Bajwa did not file his answer until 2016 in, I've forgotten the month.
Yeah, I think you said early June.
June 1st. So he was not entitled to anything at the time we had the arguments. You know, the time hadn't expired for providing that information.
Well, I'm not sure that that's right. The argument on the motion to dismiss was held in mid-November, 6 months after the answer was filed, after the Bajwa answer was filed, and the record seems to say that soon after answering, he served discovery requests, and the plaintiff's disclosure statement would have been due 40 days after that.
Right.
And the discussion at the argument seems to proceed from the common ground that none of those had been responded to.
None had. That is correct.
Okay. Did the plaintiff take any action after receiving the mid-July notice that the court had placed the case on the inactive calendar for dismissal? Did the plaintiff take any action to comply with that notice thereafter?
Your Honor, I did not receive that notice. You know, I'm a sole practitioner. I was with Snell and Wilmer for a dozen years before I moved to the East Valley, but I did not receive that notice, and I found that I've had problems with the post office delivering those things, and I did not receive that notice. Had I received it, I would have acted in some manner to find out what was going on and what I needed to do, but I did not receive that notice.
Have you checked your files to ascertain that?
Yes, I did.
Okay.
When it was mentioned in these proceedings, I became concerned as to why I didn't receive that notice.
Did that come up at the November 2016 argument? Did you?
No, it did not. I had asked Judge Talamonte for additional time, but I was not aware of any pending motion to dismiss or dismissal calendar.
I thought
I simply wasn't aware of that.
maybe I'm misunderstanding the record. I thought your request for an extension was filed in response to a motion to dismiss that had been filed September 12th. Your request for extension was filed the end of September. Was it not in response to that motion to dismiss filed September 12th?
I think we were asking whether it was in response to the motion to place it on the inactive.
No, I
case.
understood your question, but he indicated that he was unaware of a motion to dismiss at the time that he requested the extension.
No, I was not aware of
Okay.
the placement of the case on the inactive calendar for dismissal.
Okay. So I'm misunderstanding what you're saying. You were aware of the motion to dismiss by the party, you just weren't aware of the courts.
That's correct.
Okay.
And I filed my request for extension of time in September of 2016. Tried to remind Judge Talamonte of my need for an extension, which he abruptly denied. I didn't get much of a look-see from Dr. Talamonte in that argument at all. And I was, shocked and surprised that he didn't give me the additional time that I had requested. If the court has any questions of me, I'd be happy to answer them.
I think we're done. Thank you.
Thank you.
Good morning, Your Honor. My name is Lou Ann Rosen, and along with Susan McClellan at council table, I represent Dr. Bajwa, and Attorney Allison Freeman is also here with regards to the other defendants. And I think the record in this case does support that Mr. Porter did not diligently prosecute the case. The complaint, as you know, was filed in October 2015, and within 15 days, Dr. Bajwa's counsel contacted Dr. Bajwa, who had heard about the case through defective service attempts on Dr. Smith, and was contacting counsel, and counsel wrote to Mr. Porter and said she would be representing Dr. Bajwa. Please send an acceptance of service form, which was never done. Approximately 4.5 months later, she contacted Mr. Porter again and said she was willing to accept service, and that was in early March of 2016. And then she did file or sign and return the acceptance of service on March 14th of 2016. For whatever reason, Mr. Porter didn't file it for another little bit more than 2 months. And once it was filed, Dr. Bajwa did timely answer on June 1st. Because he had timely answered that, then created the dates to start running on the Rule 26 disclosure statement. And at that point in time, he had not yet served an expert affidavit either. When the Rule 26, and also in the initial letter, Ms. McClellan had sent medical releases for his client to sign and return. And then once Dr. Bajwa was served and she filed the answer, she also had propounded some discovery. So Mr. Porter never responded to any of the discovery requests, never submitted a Rule 26.1 disclosure statement, never returned the medical releases, which were then asked, all of that was asked for again, including the Rule 26.2 records exchange. As of the hearing on November 9th, none of those items still had been produced, as Mr. Porter just indicated was the case. When she made several attempts in August, and this was after the July order from the court that Mr. Porter says he didn't receive, but even after that, Ms. McClellan wrote to Mr. Porter and said, everything is overdue. We need you to get this information to us. And at that point, he indicated that he was at a wedding of 3 of his grandchildren in Utah, and that he would submit those documents by August 20th, I believe it said, of 2016. And so when that still was not forthcoming, at that point, defense counsel filed the motion to dismiss for failure to prosecute. And notably, the court didn't dismiss just for the failure to produce an expert affidavit, but went through the facts of the case and dismissed it for failure to prosecute. In fact, he said, if this were merely for the failure to provide an expert affidavit, I might give you more time. When Mr. Porter says that the court didn't allow him to address the issue of the, I'll call it the timing issues relating to the length of time that it served for service and then for the answer, he did allow him to address that, which further disclosed what the information was, that although Mr. Porter had attempted to serve Dr. Bajwa, he tried to serve him first at an office where he no longer worked, and second at Dr. Smith's home, where he didn't live. And even in those circumstances, counsel for Dr. Bajwa said, we're happy to accept service, just send us the form and we'll accept service of this case. And that was within a couple of days of the attempts of service, which I don't think counsel was even aware that there had been attempted service at that point in time.
Taking away I realize this is a big taking away, but if you subtract out the amount of time before service, if the service had been effectuated within a month, would the time frames warrant a dismissal? Anything that happened post service, post answer being filed, would the time frames justify a dismissal under those circumstances?
I believe that it would, because I don't think that the facts would really be any different. Mr. Porter had filed his case.
But wasn't there only one failure to respond to a letter? He had said he would have something by August, and he didn't have it until September. Would that be a justification for a dismissal?
Well, I believe it would be a justification for dismissal in this case. And I don't know if you're saying take away all of the prior communications so that you only have the one communication.
Well, I'm just saying from the time of actual service and the filing of an answer, at that point, it doesn't seem like an extraordinarily lengthy period from there. Again, there's a notice that the case is being placed on the inactive calendar.
Correct.
And presumably an incentive to do something. But at the time the first letter was sent asking for disclosures within 10 days, it was actually before they were due. It was less than 40 days after the answer had been filed.
Right.
So, I mean, it seems...
Right. So I think what you're saying, if you go with the June 1st service date, that you only have about 4 months time period by the time of the oral argument.
Right.
And I don't know if that would be correct, because that those aren't the facts of this case. So he had been aware all along of his requirement to meet the obligations to provide the discovery responses. They were late. I wouldn't say that this is a situation where defense counsel was laying in wait to try to is going to miss the deadline, and on that day that he misses the deadline, we're going to go ahead and file the motion to dismiss. I think if that had been the case, Judge Talamani probably would have taken a look at that. But this case had been ongoing. There had been efforts by defense counsel to effect service, to get the medical releases that she needed to proceed with the case. So I think that defense counsel was working to process the case, where plaintiff's counsel was basically not responding. He talked about his, certainly we're all empathetic to his health conditions. The heart attack issue that he raised was, I guess, in November of 2015, which was well before the date that he had promised. He had promised to provide the discovery responses in the Rule 26.1 by August 20th of 2016. So there were, he didn't mention any health issues at that time. It was that he was at his grandchildren's weddings, and Ms. McClellan was certainly happy to extend his deadline. So it was just the continued failure to provide anything to prosecute the case, any Rule 26.1 disclosure statement. And by the way, the doctors that Mr. Porter mentioned this morning, I don't think you'll find their names in the record anywhere. This is, Ms. McClellan said this is the first time she's heard any of those names.
I think they're in the briefing.
They might be in the briefing? Okay.
I think I remember seeing them in the briefing. But if we disagree that the remedy for a defective affidavit is dismissal without giving some opportunity to cure. In your view, is there enough without relying on the fact that there was a defective affidavit? There's enough to affirm?
I think there is enough to affirm. I think there's enough to affirm by the fact when the affidavit, as you mentioned, was provided, it is defective. It's from a specialist and not a general dentist, and 122604 says it must be from a general dentist if your case is against a general dentist. And this, Mr. Porter had conceded an oral argument that his...
Doesn't the rule provide for an opportunity to correct a...
It does. And I think if there had not been so much delay, that maybe that would be an acceptance. And the court could have done that. And the court, in fact, said, if this was merely the failure to provide the expert affidavit, I'd probably give you more time.
The merely when it has been provided, admittedly a little bit late.
1 day before argument,
Right.
and defective and unsigned.
But the defective part is curable.
It is curable.
It's the lateness, you're saying that was late, and then just coupled with all the other factors.
Yes, and I don't think that the judge would have dismissed it just on that basis, at least with prejudice. I think he would have allowed an opportunity to cure if that was the only issue. If plaintiff had provided the timely discovery responses, provided the Rule 26.1 disclosure statement, it wasn't just the expert affidavit in this issue. And I think even if it had been under the Passmore case, I think he still would have had the discretion, and I do believe this is an abuse of discretion standard, not de novo review under the facts of this case. I think he still would have had the discretion to dismiss the case with prejudice based on the failure to provide the timely expert affidavit. I also believe he had discretion to dismiss the case. And I would say the record isn't clear on this, that he did this, but I think he also could have dismissed the case with prejudice under Rule 37 for failure to provide disclosure and discovery responses. There are no further questions.
No, thank you.
Thank you.
Mr. Porter?
Does other counsel wish to be heard?
Oh, I'm sorry. I was assuming.
Thank you. We've joined in all the
Oh,
arguments.
thank you.
Thank you.
Okay. Many of the circumstances that contributed to my failure to do what I should have done in this case related to my health concerns. Not only did I have the heart attack and the convalescent problems associated with that and my recovery, but I'm also a cancer patient. I didn't mention that, but I've dealt with 3 types of cancer. First was Hodgkin's disease, lymphoma, and that was while my wife was still alive, and we dealt with that. And then after her passing, I dealt with bladder cancer, carcinoma, transitional cell carcinoma. And that was while I was in Utah visiting family as well. And my son, who's a physician up there, called and asked me to come in on a Saturday, which I did. And he gave me a physical for my birthday. And he gave me a physical, and he found some dark spots in the abdomen area and said, I'm going to send you up to my sonogram tech and let him take some pictures, which he did. And then disclosed that the pictures that his sonogram tech had taken showed 3 tumors. They look like mushrooms. They like little mushrooms growing up inside the bladder. And he referred me to a Dr. Cronmiller, who was not a urologist, but someone who dealt with that kind of information. And we met with Dr. Cronmiller on a Sunday at his home, and he had a small lab in his home, and he looked at the pictures and came back in after spending 15 or 20 minutes looking at the pictures and asked me, "What are you doing Monday morning at 10 o'clock?" And so I was scheduled for surgery that quickly, and he removed the 3 transitional cell carcinoma and began treating me with the chemo, and it took several types of chemo before he found something I was not allergic to. And he began treating me with that, and then he did another cysto exam, which scoped my bladder and showed the pictures were broadcast on the wall in a monitor, and I saw what he was looking at. And when he finished, I said, "What was that red thing about the size of a penny that showed up on the screen?" He says, "I didn't see that. I'm going to have to go back in and take another look." He would, and so he did take another look, and he found what I was referring to, and that was a carcinoma in the situ, which is different than the transitional cell carcinoma, because the carcinoma in situ grows at the base of the bladder and tries to exit out downward, whereas the transitional cell carcinoma is a mushroom type. It tries to go up in the bladder. So he then referred me to Dr. Lamb, a Donald Lamb, with whom he had done a fellowship in Virginia. And he was a doctor that was specializing in oncology and urology at Mayo Clinic in Scottsdale. So I went to Dr. Lamb because I lived here, and it was more convenient to me to go to Dr. Lamb.
You know,
Then-
sir, I'm going to have to cut you off because your time has run.
I'm sorry.
We take your point that you were undergoing cancer treatment.
Well, I just wanted to let the court know that it was not just my heart that was giving me problems. I was having problems with bladder. I had to have my gallbladder removed on an emergency basis. I just had lots of unexpected medical complications.
I understand. Thank you.
Thank you very much.
Thank you to both, all sets of counsel for your argument and for your briefing. We'll take the matter under advisement and we'll issue a decision in due course. Now we're going to recess to allow the next case to set up. Thanks.